and Mr. James Kitchen, if he is available. Mr. Kitchen, I've seen that you have been present for most of the presentation, so I don't think I need to repeat myself about the time frames that are available for you.
Yes.
If you wish for me to warn you then about times,
No, that's all right. Thank you, Madam Chair. Honorable members. Kitchen James, for the record. Since it seems somewhat relevant to some members of the committee to inform the committee of my new budget credentials, I'll just let them know that I was born in the Chalmers Hospital, raised in Fredericton. I got married in Fredericton, my children were born in Fredericton, and I obtained both my degrees from UNB. So I care very deeply about what happens here, and I'm not just a fly-in from another jurisdiction. After some brief introductory remarks, I'd like to discuss specifically the religious rights of parents as protected by Section 2A of the Charter, and then I'd like to discuss also Section 7 of the Charter. I'm very open to any other questions about any other constitutional matters, but those are the ones I'm going to focus on. After my introductory remarks, I invite you and encourage you to interrupt with questions, but of course I'll leave time for questions at the end as well, but please feel free to interrupt if something comes to mind. I'd like to start off with a quote that frames my discussion. This is from Chief Justice Dixon, as he then was, in the Big M Drug Mart case. He says, "A truly free society is one in which can accommodate a wide variety of beliefs, diversity of tastes and pursuits, customs, and codes of conduct. A free society is one which aims at equality with respect to the enjoyment of fundamental freedoms. Freedom," he says, "can primarily be characterized by the absence of coercion or constraint. If a person is compelled by the state or the will of another to a course of action or inaction which he would not otherwise have chosen, he is not acting of his own volition, and he cannot be said to be truly free." One of the major purposes of the Charter is to protect, within reason, from compulsion or constraint. Coercion includes not only such blatant forms of compulsion as direct commands to act or refrain from acting on pain of sanction. Coercion also includes indirect forms of control which determine or limit alternative courses of conduct available to others. Bill 39 proposes to change the status quo in New Brunswick, which currently permits parents and children to freely choose whether or not to receive vaccinations and still fully participate in public life and equally benefit from public services provided by the state, such as public education. In place of that status quo, Bill 39 will introduce a regime, the only one in Canada, where some individuals, based on their choice not to receive even one of the listed 11 vaccinations that we discussed earlier, will no longer equally benefit from government services they would otherwise be entitled to. Bill 39 will result in a most undesirable situation in which some parents will, in effect, be compelled by the state to make choices that they should never be forced to make. Some may have to choose between public education and adhering to their beliefs. Some may have to choose between public education and protecting the health of their children. Some may have to choose between public education and a career. Some may have to choose between public education and affording a car, sports for their children, or even putting enough food on the table. Some will have to choose between public education and all of these things. Presumably, the intentions motivating Bill 39 are good. Intentions to ostensibly decrease childhood illness, improve public health, protect vulnerable children, etc. But, of course, the road to hell is paved with good intentions. And the state rarely takes away individual freedoms without claiming some terrible calamity will be avoided or some greater good will be accomplished. In the case of Bill 39, it is in the name of safety and public interest and protecting vulnerable children, all noble things, that rights are potentially being infringed. But as the Supreme Court of Canada has noted, the state does not have a monopoly on the public interest, nor is it the sole arbiter of what is truly safe. And it should not pretend otherwise. Truth Supreme Court has observed, and the ideal form of political and social organization can rarely, if at all, be identified with absolute certainty. You have heard and will hear conflicting views about the safety and efficacy of vaccines, about the benefits and risks of vaccines, and about the harms or lack thereof caused by vaccines. You will discover, if you did not already know, that there is little, if any, consensus on the issues among the public, but also among the experts and the professionals. I caution the committee and the Legislative Assembly against being too quick to restrict the choices of citizens and withhold public benefits from citizens who do not agree with the state regarding any issue, including vaccination. Barring emergencies or exceptional circumstances, the proper role for the government, if it is convinced of a position in regard to an issue of public interest, is to attempt to persuade its citizens of its position and no more. It should be extremely wary of engaging in compulsion, lest it become complicit in creating a society that is no longer free and democratic. Now, I'll briefly discuss Section 2A of the Charter, which, as you know, protects freedom of conscience and religion. And as you may also know, according to the Supreme Court of Canada, this right protects parents to rear their children according to their religious beliefs, including that of choosing medical and other treatments. It's a fundamental aspect of the freedom of religion. Some individuals in our society hold to minority religious and conscientious beliefs that have implications for vaccinations. They object to themselves or their children receiving vaccinations for any number of reasons. It could be the components of the vaccination, the ingredients, it could be how they're manufactured, or it could just be a principled objection to injecting anything foreign into the body. They object to vaccinations because of their religious beliefs, not necessarily because of their views or beliefs about the efficacy or safety of vaccinations. So the objection there is actually rooted in their religious beliefs about the world. It's not really necessarily anything to do with vaccinations per se. Now, clearly this is a small section of the population. However, as you're probably aware, the whole purpose of our Constitution and the purpose of Charter rights is to protect the minority. As Chief Justice McLaughlin said, when she then was, the majority is in no need of protection in any case. One of the fundamental pillars of our democracy is the protection of minorities. So there's little doubt that the removal of non-medical exemptions to vaccines will be found by a court to be an infringement of freedom of religion. And as you likely know, only one person has to show that a law infringes their rights in order for that law to be struck down, if it infringes it unjustifiably. One person, that's it. Now, whether or not that law, the infringement on religious freedom will be upheld by Section 1 of the Charter, that's a little more complicated question. As you may know, there's a test to determine whether or not impugned legislation can survive Charter scrutiny. And that test involves the government showing that the law will further a pressing and substantial objective, that it is rationally connected to meeting that objective, that it's minimally impairing of the charter right or freedom infringed, and that its overall benefits outweigh its overall drawbacks, otherwise known as overall proportionality. And the objective of Bill 39 appears to be increasing vaccination rates among school children and children attending daycare. Now, one can question whether such an objective is truly pressing and substantial, but courts tend to defer to governments on what governments consider to be important objectives for the society that has elected them. So I doubt there'd be much issue with that if there ever was a court challenge. But now we come to the other three components. However the objective is characterized, the rational connection of removing non-medical exemptions for school children and daycare children may be at issue. Now, certainly there's a connection, but there appears to be a level of inconsistency and arbitrariness involved in this because proof of immunization will be required for participation in school and daycare by Bill 39, but not for any other group activity that children regularly engage in, such as sports and clubs and church groups and after-school programs and attending sporting events and attending the Canada Day Parade, and I could go on. And I'm sure it immediately brings to mind that it would be a gross intrusion into individual freedoms and autonomy for the state to start prohibiting people from attending cultural and community events, especially private ones such as church clubs. But let's face the reality that children, vaccinated or not, homeschooled or not, public schooled or not, they get together, they hang out, they spend time together, they go to things together, like church, like private clubs, like private sports associations. Things that have layers of constitutional protection afforded by Section 2 of the Charter that would be infringed should the government start requiring these groups to require proof of their parents when they bring their children to these events. So is there a rational connection to only requiring proof for school and daycare? And that's not to say that I'm encouraging that the committee or the legislative assembly consider further proof. That's just to show that to do it in one area and not the other questions the rationality of it if the objective is truly to decrease communicable diseases being spread or to increase general health of children, etc. Now we'll go on to minimal impairment. The objectives of Bill 39, I would say, could be pursued without resorting to such oppressive policies as withholding basic public services such as education from those who hold such minority beliefs. I would say, as others have touched on, that the status quo strikes a proper balance. The balance is very important to the law, especially constitutional law. We've heard about the rights of others, and we've heard about vulnerable children, and whether you want to classify those as legal rights or constitutional rights, they're important and they matter, and I'm sure they matter for a legislature such as yourself. So that balance needs to be considered. But I would say that the infringement upon religious freedom to tell those who hold minority religious beliefs that they must forego public education in order to achieve this objective is not minimally impairing. It's maximally impairing. And I would say that there are better ways to do it, and that the legislature should consider those ways before they resort to something like this. Lastly, I want to discuss overall proportionality. And we've heard a little bit about how the benefits may be difficult to achieve. I've made the case to you that the drawbacks are pretty severe, infringing constitutional freedoms and rights. The Supreme Court considers that pretty severe. I should hope that our democratically elected officials consider that pretty severe. The population appears to consider that pretty severe. I consider that pretty severe. So this speculative prospect that we may increase vaccination rates, or we may increase immunity, we may increase health, I'd say that pales in comparison to the very serious infringement of denying public education to those who hold minority religious beliefs. Again, some of which I will remind you are not based on whether or not they think vaccines are safe or effective, but just because they have beliefs that implicate injecting things into their bodies and what those things might be. And if there's no question specifically on 2A at the moment, then I'll just continue on to discuss Section 7 a little bit. And this may be lesser known. Throughout the 1990s and the early 2000s, there were a number of cases that involved Jehovah's Witnesses and their children. These are otherwise known as the blood transfusion cases. It was out of these cases that the Supreme Court ruled, or found, that the liberty interests of parents, Section 7, by the way, protects the right to life, liberty, and security of the person. Now, this is a little bit different than how the Americans do it. Liberty in this context means physical liberty, such as being thrown in jail. And security of the person means protection of the body, of course. Everyone This is the only place in the Charter where it says this. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. So the Supreme Court has found that parents have a liberty interest in their children. Now, this might strike you as odd based on what I just told you about liberty and how it's been defined. And this is a little bit unique in our law, but this is what the Supreme Court found in the 1990s, and then it was again reaffirmed in the 2000s. Parents have a liberty interest in their children, and that's constitutionalized in Section 7 of the Charter. Now, part of the reason for this is that the rights of children to life and security are protected via their right to have their parents appropriately informed and enabled to provide necessary support and protection. So Section 7 protects everyone. Well, obviously, young children cannot assert their rights. They can't understand them. Those rights are protected through their parents. That's why parental rights matter. It's actually not about the parents so much as it is about the children. Now, I'm very curious to see what the Child and Youth Advocate will say tomorrow, and I regret the fact that I can't be here to see it and to hear it. But I actually recall when the Child and Youth Advocate came to the UNB Law School, and I attended the presentation, and that was one of the things that was discussed. It was about child rights and how children are protected, especially from the state, by the state honoring and respecting parental rights, because it's the parents that protect the children from any number of things, including the state. According to the Supreme Court, the vital link between parent and child may only be interfered with on a case-by-case basis when necessity is demonstrated and it is justified in doing so. Justice Lafayette of the Supreme Court found, and I quote, "The right to nurture a child, to care for its development, and to make decisions for it in fundamental matters such as medical care are part of the liberty interest of a parent. The common law has long recognized that parents are in the best position to take care of their children and make all the decisions necessary for their well-being. The parental interest in bringing up, nurturing, and caring for a child, including medical care and moral upbringing, is an individual interest of fundamental importance to our society. Parents should make important decisions affecting their children both because parents are more likely to appreciate the best interests of their children and because the state is ill-equipped to make such decisions itself. Parental decision-making receives the protection of the Charter in order for the state interference to be properly monitored by the courts. And it'll be permitted only when it conforms to the values underlying the Charter. Bill 39, if enacted, will infringe the liberty interests of parents and their children in a manner that is not consistent with the principles of fundamental justice because of the choices it will force parents and children to make, or, alternatively, the choices it will remove, all without justification. The reality, I submit to your honorable members, is that most children cannot feasibly be homeschooled or attend a private religious school. Yet, the New Brunswick government requires that children be educated in some fashion. For many, whether it be finances, geography, special needs, or a combination of these and other factors, public school is the only available option for education in New Brunswick. There is sufficient causal connection between the proposed legislation's requirement for full vaccination, and I find this very interesting because there's 11 vaccinations in that list, right? We've talked lots about anti-vaxxers. Well, yeah, sure, there's lots of people, or a few people, that are opposed to vaccinations on principle. They're opposed to all of them. There's also, and maybe that number is 2%. I'm willing to accept that. There's also a large number of people who are selective with vaccinations. Maybe they only want 9 or 10. Maybe they don't all want them at the same time. Maybe they want to wait. Maybe they don't hold minority religious beliefs. They hold majority religious beliefs, and they don't oppose to any vaccination except for the HPV vaccination. Now, I know that's not on your list right now, but what if it was added? Well, you'd start to catch a whole lot more Protestants and Catholics who take issue with that vaccination. So we're not just talking about a fringe of 2%. You might be talking about a minority of 8 or 9%. Who want to selectively vaccinate and maybe don't want to get all 11 of them. So I would submit there's a sufficient causal connection between the proposed legislation's requirement for full vaccination, the provincial government's requirement for school attendance, and the liberty interests of parents. As the Supreme Court ruled in the 2013 Bedford decision, the threshold is not overly high for establishing causation between the effects of legislation and the infringement of Section 7 interests in a manner that's not in accordance with the principles of fundamental justice. For many New Brunswickers, the choice to educate outside the public system is simply not feasible. Thank you. I'll end with this before I take some questions. It's extraordinarily, the reason I discussed Section 1 with Section 2A is it's quite easy to establish an infringement of freedom of religion. The real question is whether or not that's justified. Section 7 is different. It is extraordinarily rare for a Section 7 infringement to be justified under Section 1 of the Charter. It can only occur in exceptional circumstances, such as, according to the Supreme Court, the outbreak of war, or in the face of death in which a proven effective life-saving treatment is necessary to prevent the death. And I'm referring here to the blood transfusion cases. The rights protected by Section 7, life, liberty, security of the person, are very significant and cannot ordinarily be overridden by competing social interests, says the Court. Rarely will a violation of the principles of fundamental justice be upheld as a reasonable limit demonstrably justified in a free and democratic society. So I'll just close with this before I take questions. I think it likely that with this legislation, should it be enacted, would be challenged. And it's my submission that it's not likely to pass charter scrutiny. And with that, I'll gladly take questions.
Mr. McKee.
Chair. Thank you for your presentation today, and I appreciate that you're from the Fredericton area, but I understand that you're now based out of Calgary, is that correct?
That's correct.
And so are you here on your own behalf, or who invited you here, or how did you get to be here today?
I was hired by Vaccine Choice Canada, which is a citizen advocacy organization that's concerned about the potential implications for the charter rights of Canadians and New Brunswickers. And there seems to be some concern about that, as if that's unusual. And certainly in my line of work, that's not surprising. I deal with a lot of citizen advocacy groups. And it's pretty common for them to get involved in things that matter to them. Should we be discussing other social issues that would affect rights of other groups in society, they'd be here, and they'd probably hire counsel to be here to talk about their rights.
So they've agreed to pay your expenses, but have they, in addition, paid for your services here to argue a case on their behalf?
Well, yes, to be clear, that's what I meant by hired, yes.
And you're also a board member for the group, or Parents for Choice in Education, is that correct?
I am.
So are you here on behalf of Parents for Choice in Education?
I am not.
You're not. 'Cause this is the same group that is against the Gay Straight Alliance groups or student-led after-school support clubs in Alberta, that your group, that you're a member of the board, spoke out against. Is that correct?
No, it's not correct. I know what you're referring to, but that would be a mischaracterization, because Parents for Choice in Education, of course, is not against GSAs, but they are against the infringement of parental rights, which the legislation that was recently indirectly repealed in Alberta infringed the Section 7 and Section 2A rights of Alberta parents in many different ways, and Parents for Choice in Education is a citizen advocacy group that opposes that, and so they opposed that legislation and those things in the legislation that cause those infringements, which is often, of course, mischaracterized as an opposition to GSAs, but that would be a gross mischaracterization, in my opinion.
And it was your group that brought this issue to the attention of now Premier Jason Kenney, who was the leader of the UCP at the time?
One of the groups, but I think it was also brought to his attention by the fact that a court challenge was mounted.
This same group that also spoke out against the sex ed curriculum in Ontario? You're a member of that board?
No. As I mentioned, Parents for Choice in Education is an Alberta-based organization, and so it has doesn't claim to have any authority or even necessarily any interest in what happens outside of Alberta because its focus is provincial exclusively.
So it never issued any opinion or any statement on the Ontario sex ed curriculum issue?
Not that I'm aware of. Perhaps you have the Parents for Choice in Education confused with an Ontario organization that's very similar. I think it's called PAFE. I'm not associated with that group at all. But
no, I'm not confused. But
okay.
If you don't recall, that's fine. And just to be clear, the group Parents for Choice in Education, for which you're a member of the board, that is a group that would be well connected or funded by religious organizations?
No. And I fail to see how this is relevant to the discussion.
I just want to get a bit of background on yourself and to see, if there's any bias in your opinion or whatnot. So I'm just.
Well, I'm biased in favor of constitutional freedoms. I am a constitutional litigator, so I am biased in favor of seeing a free society and of rights not being infringed without justification. So I'll freely admit my bias in favor of the free society.
No, I just want to know what your background is and if you're funded by religious action groups and bringing.
I believe your time has expired, Mr. McKee. Thank you very much for your questions, but I will allow the witness to just provide the information.
I'm not funded by any individual or group. I'm a lawyer, and I get paid by my clients who ask me to represent their interests. So I think the question is a little misguided, and I want to clarify that I'm not funded, I'm paid as counsel.
As is Mr. McKee in his previous life as well.
Of course.
Mr. Savoy.
Thank you, Madam Chair. So thank you for being here, and I certainly appreciate the questions Mr. McKee brought forward. So you're a hired gun for Vaccine Choice Canada. They're paying you. That's fine. There's nothing wrong with that. Do you know who funds Vaccine Choice Canada?
Presumably private donations, voluntary donations from Canadians. It's pretty common for citizen advocacy groups to accept donations, either as charities or not as charities, to advocate for their interests. It's a pretty common feature of a free society.
Okay, no, that's fine. I just didn't know if there was any big donors or anybody that you could name. So
well, that's not really my concern.
Well, that's fine, but I'm here to ask a question, and if you can't answer it, that's fine. So you mentioned various points about infringing on minority religious beliefs. So here in New Brunswick, because that's where this Bill 39 will apply, can you name any religious groups that would have an issue with receiving a mandatory vaccine specifically?
I'm aware that there are certain sects or groups or denominations of of the Christian religion and of the Jewish religion, I think, that do have objections to what goes into their bodies, at times anything. I do believe that Jehovah's Witnesses have very strict beliefs about what goes into their body, which I think relates to the issue of blood transfusions. So are there Jehovah's Witnesses and those groups of Christians in New Brunswick? Well, I'd be extraordinarily surprised if there wasn't.
I'm a Roman Catholic. I'm not aware of any restrictions on my religion. I have two sisters who converted Jehovah's Witness, and your blood comment is correct, but the other one is not. They've been vaccinated and continue to be so. So I was just curious if there was anything outside in your experience that you could give anything direct on, but that's okay. So you're a lawyer. You've given your legal opinion, which is fine. I appreciate that. But there are other legal opinions who believe that it would survive a charter challenge. And I'm asking you for your legal opinion on this. So the idea would be that, first, it would likely be viewed as a reasonable limit on a parent's right to freedom of religion and conscience, and it's the rights of the child that are at stake. Secondly, no protected right that parents enjoy is violated by a mandatory vaccine rule. And this is from a Dr. Ogbogu, Professor of Health Law at the University of Alberta. You're in Calgary, so you may be aware of him. Just was wondering if you can give me a legal opinion on that. I know what you've said on your side. I want to hear if you can give me any veracity or any support to that side, or if there's any support at all.
I think it's an open question. I don't think it's a slam dunk either way. Constitutional litigation is always extraordinarily risky. It's essentially political philosophy, and although there is stare decisis, the court goes back and forth. Many people believe that the Trinity Western decision was an abandonment of stare decisis, because in 2001 the court ruled that Trinity Western could have an education school, and then less than 20 years later they ruled that they couldn't have a law school. So the Supreme Court bounces around depending on the composition of the court, depending on the political philosophies that are at play, the social conditions. The Bedford decision is overruling a prostitution case from the 1990s. So I should expect differences of opinions, and I certainly don't claim that mine is somehow superior to anybody else's. But to comment directly on what he says, especially following the Trinity Western decision, the court seems very open to justifying limitations on freedom of religion under Section 1. So I would say that the bill may very well be upheld in that respect. That criticism doesn't deal with the Section 7 issue I raised. You raised a second. Sorry if I'm just going with your question. You raised a second issue about the security interests of the children. I didn't get into this based on time, but I think if this is litigated, you're likely to see a lot of evidence brought into the court process about the safety and efficacy of vaccines and about all their injuries that have been suffered, etc. And that will implicate the security interests of the children. So some will say that the security interests of the children require that parents permit them to be vaccinated, or that the state force parents to let them be vaccinated. But an argument can also be made that the security interests of the children would be best upheld if parents were able to make choices about whether or not the child is vaccinated, because there's been harm.
Ultimately,
Thank you for your question, but we've now exceeded our time. If we have time, we will circle back around.
Chair. Thank you for appearing here today. You've certainly given me some food for thought, and I'll keep your thoughts in mind for future considerations. You haven't said that your specialty is constitutional law?
Yes.
Okay. In your opinion, would this proposed Bill 39 stand a charter challenge?
If I have to make a guess, I would say no.
Okay. Can you point me to the areas of the bill that you think would violate the charter? Just for my information.
Well, the bill is rather simple. It removes 3 exemptions, one of which I will note is not a religious exemption. The exemption in the Public Health Act is simply an objection. It's not specified whether or not it's supposed to be religious or otherwise. It just says parents are to say that they object, and that's it. Now, in the other 2 pieces of legislation that would be amended, it is religious objection. So the point of the current status quo is to protect religious rights. Well, incidentally, it also protects Section 7 rights. So right now, parents, whether or not they're religiously opposed to vaccines, use these exemptions, right? So their Section 7 and 2A rights are upheld. If you remove the exemptions, you don't just implicate 2A, you implicate Section 7. And I think that's where, based on my previous comment, unfortunately, in my personal opinion, justifications for the infringements of religious freedom in Canada seem to be readily accepted. So where I think the weakest point of the bill is Section 7, and so which is not something that's going to pop right out, because none of the current legislation says out of respect for Section 7 you're allowed to exempt the vaccinations. It talks specifically about religious beliefs, but incidentally it also protects Section 7. And what's going to happen if you take the exemptions away is you're going to get litigation, and Section 7 is going to be pled, and that's where I think the bill is not going to pass charter scrutiny.
Thank you.
Kitchen, we have now reached the We've actually exceeded the time that was allotted for you. And once again, appreciate your attendance here today.
Thank you.